As president of AFCC, I want to welcome you all, enthusiastically welcome you to our 43rd annual conference, In Whose Best Interest? Juggling the rights, needs, and interests of children, parents, and families. It's Nancy Versteeg. She's a law professor at William Mitchell College of Law in St. Paul. She's a mediator, and she's done considerable work in the domestic violence area with battered women. I present to you Nancy Versteeg.
This morning we're going to talk about best interests. And I sometimes tell my law students it's a sure bet phrase to include on a law exam or a bar examination. It sounds authoritative, best interests. It applies to almost anything, and bar examiners certainly expect to see it. But our question here today is, what does best interest really mean? Is it something that we can articulate clearly, or is it something that we kind of know it when we see it? Whose best interests are going to be more important? When family members have conflicting best interests? I guess we could think of it in terms of whose best interests are the best interests? Can we really consider the best interests of any individual family member in isolation from the other family members? Well, these are interesting and perplexing questions. And fortunately, we have with us today a panel of very thoughtful experts who are going to shed some light on this. David Hoffman, sitting in the center. You are a mediator and a collaborative lawyer. You're the immediate past chair of the ABA Dispute Resolution Section, co-editor of Bringing Peace into the Room, which many of you may be familiar with, co-founder of the Massachusetts Collaborative Law Council. Let me give you a hypothetical question, and let's see what you make of it. Assume that mom and dad are getting divorced. They have 3 children, a girl 6, a girl 12, and a boy who's 17. Now, mom's been more involved with the day-to-day life of the kids during the marriage, and she genuinely believes that she's going to be the best person to be the sole physical custodian of the kids after the divorce. Dad, on the other hand, sincerely believes that he would be best and could do best as a parent if they had joint physical custody. So how can you help this family, Mr. Hoffman?
First of all, please call me David. Second, let me just say that I think one of the most important things as a lawyer, collaborative attorney, and mediator is for me to remember my limitations. And I would like to just identify 3 major limitations: expertise, data, and tools. On the expertise front, although I've been practicing family law for 22 years and mediation for, I guess, about 14, I don't have training as a mental health professional. I'm married to a therapist, and so we talk about various things at dinner each night, but that gives me just enough expertise to be truly dangerous. And I have to remember, and I heard an interesting talk recently about how those of us who get involved in doing work with families, if we're not mental health professionals, nevertheless, if we're interested in people, we may develop a certain facility in talking with people about these issues, and pretty soon we start thinking we're good at it. And that can be very seductive because people say, I know this isn't therapy, but this is very therapeutic, the way you're handling the situation. And so remembering our role boundaries is really important. On the data front, the case that you just described, I've got that case. I mean, the ages of the kids are a little different, but I had that case both as a mediator, and I have another version of it as a collaborative law attorney. When the wife, my client, came to me asking me to be her counselor, her collaborative law attorney, I was totally sold on her as the most skilled, effective, and appropriate parent. She described behaviors on the part of her husband that sounded very narcissistic and sounded like a real bully. And you know what they say about family law attorneys, and in comparison with criminal defense lawyers. Criminal defense lawyers see bad people at their best. Family law attorneys see good people at their worst. But there's a corollary to that principle, which is that we see our clients at their very best on the day that we meet them. They will never be more appealing than on that day. And therefore, we need to be mindful that they may have faults that we don't see on that first day, including faults with regard to their parenting. And there's nothing more seductive, and I don't mean that in a sexual way, I just mean in an interpersonal way, than the client who comes to you being very candid about her limitations and the fact that her husband has never admitted any fault about anything in his whole life. So in that case, where I was the lawyer, I was totally sold on the parent being the mom being the appropriate custodial parent. So remembering that we're only seeing half the data, and not even a full slice of that, is an important limitation. And then as to tools, collaborative law and mediation are extremely powerful, important tools. But they do not provide the tools, for example, that Dr. Ritchie has as an evaluator when you're performing that role. And I know you're doing other things as well. Nor do we have the same tools that are available to a judge. I think that I saw so many hands go up when you asked about mediators. Can I ask a show of hands? How many of you, if someone asked you to explain what collaborative law is, show me, raise your hands. How many of you would feel comfortable explaining collaborative law to someone? Well, that's terrific. And it's about half or 40%. For those of you who did not raise your hands, what I want to emphasize about collaborative law, and I've got about another minute and a half in which to do it, is that the parties sign an agreement. And not only do the parties sign an agreement, but so do the lawyers. You have 4 people signing an agreement. And that agreement is an enforceable legal contract. And it has among the provisions, at least the collaborative law process agreement that I use, and it's similar to the ones used around the country. It says that we are going to engage in respectful communication. We're going to use joint experts if we need experts. And that's a very important provision of the agreement. It also has provisions saying there will be no disparagement of the other parent to the children, no discussion of divorce issues with the kids, and that the parents agree to make every effort to reach amicable solutions that promote the children's best interests. Now that document is signed right at the beginning, and that means this is an important tool for the lawyers and for the parties because we can refer back to that contract if we feel that some solution that's on the table doesn't meet that standard. And so that's an important commitment for people to make at the front end. With regard to mediation, I would just say one other thing, and that is that I think those of us who are mediators have found that the case that you described, the differences about what the parenting arrangement should be may be more theoretical than real. They may be profound, but they may be just a question of going to the whiteboard and mapping out, okay, what do you think is the best parenting plan? And then the other person, what do you think is the best parenting plan? And working on those differences. But if they're as profound as the ones you described, then we may need to call for greater expertise.
All right, let's call in Dr. Ricci. Dr. Ricci, you are a marriage and family therapist with many years of experience working with divorce, with co-parenting, with child adjustment. You're the author, of course, of Mom's House, Dad's House, and the new Mom's House, Dad's House for Kids. You headed the statewide office of family court services for all of the California family courts. You were the assistant director of the Center for Families, Children, and Courts, and she has been an AFCC member since 1974. Wow. Dr. Ricci, how do you typically become involved with families such as the one we've described, and how can you enhance the process?
First of all, perhaps they may be referred by the court, in which case they're already a little bit further along in the dispute than I would like. They may come to me because a friend of theirs said, well, why don't you try talking to someone before you actually see a lawyer? Or perhaps an attorney says, why don't you go? Or the 2 attorneys say, let's find someone to talk to, not necessarily a mediator. Believe it or not, there are people who don't particularly trust mediators, and they may not trust lawyers. And so they're trying to find someone else who might be a neutral along the family therapy approach. So one of the first questions I would ask of the person who called about this case is, where are they in the legal process? That would be one of the very first questions that I ask. The second thing is, would I be working with the whole family, with just one of the parents, or would I be working with both parents? That would make all the difference in the world in terms of what my approach would be. Let's assume that, that I'm actually going to work with both parents. In that case, I would ask them to tell me where they are in the legal process. Then even if they told me where they were in the legal process, I would still ask for a release of information to talk to an attorney if either one of them had engaged an attorney.
Judge Carbon, you are a family court judge and have been since 1991. You were a key player in bringing the unified family courts to New Hampshire. You are the vice president of the National Council of Juvenile and Family Court Judges, and she will be president next year. Yes. She's trained nationally and internationally on domestic violence and family issues, is the author of many books and articles, and is also a consultant to the U.S. Department of Justice. As a sitting court judge, how do you and when do you meet mom and dad, and what do you hope to accomplish for or with them?
I think that courts, judges specifically, want what everybody else here on the panel wants for families when they're going through separation and divorce, and that is to achieve the best outcome that we can and to help families through what is a very traumatic process for them with the least amount of pain and angst and with the most amount of dignity left at the process. This can be extremely difficult when families do come into a court setting. For starters, let me say that courts are neither, we can neither accept nor reject clients. We take what comes in the door. We are gatekeepers to a legal process that people need to go through in order to have their new relationships formalized. So whether they are coming into court voluntarily or otherwise, they do need at some point in time to have their restructured relationship, if you will, their divorce or their parenting agreement approved by a court. So we take what comes in, there's no screening out, we have no selection process, we take it all. Now, having said that, we recognize that litigating divorce and parenting cases is not always the best process. In fact, it can be very counterproductive to the families and to the kids because it often pits family members against one another. You come into court and you say the worst possible things you can about the other parent so that you can win your kids. And we're trying very hard to get away from that win-lose mentality so that people understand that your children are not your widgets that you get to possess or loan out from time to time to the other parent. So we're continually seeking non-litigation resources for families in hopes that we can refer them to experts such as David and Isa to help them resolve their own conflicts themselves, either as court-annexed services or as community-based resources, so that they can attempt to resolve the cases on their own before they come into court and ask the court to approve an agreement that they might have prepared. Courts are increasingly front-loading services so that when parties come in, we may be able to direct them to mediators, for example, before they actually file a petition for divorce, so that they might have opportunity to work with someone and resolve in an amicable way what their disagreements may be. And even if they come in, if they were not aware of these other community resources, in states like New Hampshire, if they've not yet accessed mediation when they filed, we have the authority now to order them into mediation to see if that might be an opportunity to help them resolve their case first. We start out with an assumption that both parents are competent, caring individuals and that they have the capacity to make sound decisions for their children, and that they would know ideally what would be best for the kids. So we do try to refer them to other professionals who might be able to help them in the first instance. But we also assume that there's going to be a certain amount of pain and angst that they're going to go through as a result of the separation, whether it's just difficulty dealing with the trauma themselves of now having their life shattered in pieces. So they may need to deal with those kinds of emotions first before they are capable of looking at what the best interests of the children might be. So we will also encourage them to seek other resources besides legal resources to help them with that process as well. So as courts, we get families coming in one of three mechanisms. Either they come in because the public does not know what the community resources are, so we will tell them about it when they file. Secondly, we might get families who have tried all these other methods and they didn't work, so now they're coming into court to have us resolve them through a court process. or it could be some other type of case where it was not appropriate for mediation, such as serious domestic violence or substance abuse or mental health issues. So regardless of which way it may be, by definition, when families bring their cases to court, we, the court, the state, if you will, are being asked to substitute our judgment for the judgment of the parents and make decisions for them that for one reason or another they're not able yet to make for themselves. But at the same time, the ironic twist of this is that we recognize very sincerely that parents know their kids far better than we will ever know them. We can see them from time to time over the course of a few months or a year, depending on how long their case lasts. We may have a couple of hearings that may last a few hours long. It may be a 3 or 4 or 5 day hearing. But we will never know the kids and the parents as well as they know themselves. So with that in mind, it becomes even more difficult when we have pro se parties who don't have attorneys for whatever reason they've chosen not to, whether they can't afford them or they don't want to hire an attorney, they want to do it on their own. Judges have increased responsibilities when we're dealing with parties who are not represented.
Well, the phrase best interest is most commonly used with respect to the best interest of the child. And you have in front of you a sort of typical statute that states, many states have statutes addressing best interest of the child, and many of them have factors that are supposed to guide the court or decision makers or families in deciding how to decide about best interests. They're all different, but here's one that we might say is typical. Judge Carbon, you have to apply the law every day in these kinds of situations. How do you deal with the factors that we've just been talking about? Are some more important to you or not?
Well, I think you've hit upon the $64,000 question that judges face day in and day out when we're dealing with custody disputes between parents. Everyone deals with this. There is no, and I think we've reflected this in all the discussions that you've been having at the tables as we were walking around, there is no one right answer. There is no one family for which there is a right answer. And it sounds trite, but it is so true. Everybody within a family has their own reality of what may be in the family's best interests. It may be in mom's views. She may have a whole perspective that is very sincere and genuine to her based upon what her experience within the family may be. Similarly with the father and with all of the children. If you can think back for a moment when you're growing up with your siblings, for those of you who have multiple siblings in your family, all of you, whether you're the firstborn or you're the 12th down the line of a dozen kids, your perception of reality within your family is governed by so many things based upon where you were, what your relationships with your siblings were, and your parents, and what age group you were, and how your parents interacted with you, depending on where you were in the chain. The same thing holds true when parents get divorced. Everybody comes into the process with a very different reality that is very sincere and genuine to those people. So we have to peel back those layers and look at them and try to figure out what's going on there. We're also being asked here, when we have these beautiful lists of best interest factors, to take these and try to predict the future based upon the family's past behavior. That is extraordinarily difficult proposition. And we can try, but there are some inherent limitations in doing that and making those future predictions. And what we do and what we know will, based in part by what they're telling us, but we really need to gather as many facts and not just people's discussions or opinions or interpretations of what's going on. We really need to look at objective information. But in trying to gather that objective information, we may apply and we may call upon other experts to assist us in making those determinations. And whether it's mediators or custody evaluators or psychologists or guardians ad litem or whoever it may be, they will be utilizing a whole host of different potential tests. There are some 2,000 tests that could be used in making evaluations. So depending upon what tests are used, who the evaluator may be, and who the judge may be, you have a whole constellation of different possibilities to make a decision about what is in that family's or that child's best interests. So it is a very difficult, complex layering process to try to figure that out. And you could have one family and as many judges in this room who are here all hearing the same information and walk out with a different determination about what might be in that family's best interests or in the child's best interests. So I always start out, even though on the list that we have here, you will see that domestic violence is down in the second tier of factors, I always start out with a safety assessment for a family, both of the parents and of the children who are involved. because I will fall back upon the medical term, if you will, the admonition to do no harm. As a judge, I would never want to do anything that would cause physical or emotional harm to a child or to a parent. So it's very important to me that we do that screening early on. There may be more layers of screening that occurred later, but in the first instance, I'm going to look for that to make sure that there are no safety issues involved in the family. So I'll screen carefully to try to make sure that the kids feel safe and that there are no issues that I need to be mindful of to know whether making referrals for mediation or other sources might be appropriate. So I will be looking for factors such as whether there is any psychological abuse going on in addition to any physical abuse that may have happened, and then post-separation, what additional factors may be occurring, because it's not enough to look at a point in time when the family separates. You need to continue looking and see what has happened since the date of separation moving forward. See if there have been any additional harms. See what trauma a child may experience. If a child has observed or witnessed or been affected by domestic violence, and there are many different layers of that, that may be only the beginning for that child. That may simply be setting the stage for a lot of trauma that will go on down the road. So you need to be mindful that there will be other potential consequences and implications of what has happened in the family as you're working with that family going through their case. So you also need to look at the kids' attachments to their parents, understand whether they're healthy attachments or unhealthy attachments. And again, for that, we rely upon other professionals to guide us, because we are not psychologists. Unless you have a judge who is trained in that field, we can't pretend to be parapsychologists and doing something for which we are not trained. That is extremely dangerous for us to do that. So we do, though, be aware that we need to be looking for other information and try to understand what the nature of the relationship is, and as well the nature of the relationships between the kids and their siblings, and each parent between each other. So we also look as well, once we've looked at the kids, about what the parents' relationship is with one another. Do they support one another as parents? And we typically hope that they do, and in a healthy relationship they would. But if one parent is not supportive of another, is there good reason for that parent not to be supportive? If that parent has been abused by the other parent, we need to be mindful that their hostility, if you will, or their reluctance to trust the other parent may be based on very good reason. And if we're not looking at that relationship in the context of where they've been and whether there has been violence in that relationship, we may be doing a disservice or unjust result for that family, because we have not understood what has been occurring in that family. And although our intentions may be well, we may be doing a real disservice to the family if we don't truly understand what's going on.
All right, new hypothetical situation. Assume that mom and dad have actually been divorced for 3 years. They have 2 children, an 11-year-old son and a 15-year-old daughter. Mom wants to move to another state 500 miles away. We're going to do a little opinion polling here. Now, statutes on relocation are all over the map, so we're not going to go in that direction. We're going to talk about some of these underlying interests. So get your arms ready to do a little voting. Let's look at this from the perspective of each family member, and then our panelists are going to have an interesting task of how to mesh all of this. So let's start with the 15-year-old girl. She is opposed to the move. She doesn't want to leave her friends. She doesn't want to change schools. And she's hinted that she might run away if this move takes place. Now, everybody think that this move may not be in her interests? Probably. Would you change your mind, though, if you learned that she had a 24-year-old drug-dealing boyfriend? Now is the move in her best interest? Maybe? Okay. 11-year-old. He's doing poorly in school, being bullied by classmates. His teacher says, you know, it'd be a good thing for him to go to a new school, have a fresh start. His best interest to move? Could be. But would you change your mind if you find out that he's been diagnosed with a learning disability, and the school psychologist says that if he moves, he's going to be set back quite a bit scholastically? Not in his interest to move? Possibly not. Well, enough about the kids. We've been talking about kids a lot. Some of you must be parents. Don't you have rights, needs, and interests as well? How do we fit this all together? So let's talk about mom. Mom wants to move to state B, where all fictitious people move, by the way. The reason she wants to move is that she's got family there. She grew up there. She's got extended family she wants her kids to know. She has a job there that is going to pay more than the job she has. And she's engaged to a man who owns a small business there. So obviously she has some interest in moving. Now, how would you look at this if, as in hypotheticals we can say these things, it wouldn't be so good for the kids to move? Would you weigh mom's interests and the kids' interests equally? How many of you would say that they should be weighed equally? Not a single person, okay? How many think the kids' interests should be weighed more than mom's? Okay, a definite majority. Panelists, you'll have to think about that. Dad, let's talk about Dad. Dad opposes the move, not surprisingly. He's worried about his ongoing relationships with the kids. He's also worried about what's going to happen to relationships with his extended family members, and he is deeply concerned about being replaced by mom's new fiance, especially with the move. So, not in his best interest. Should his interests, though, be considered? Is Dad a factor here? How many say Dad's interests should be considered? Okay, pretty solid majority there. Say that the kids' interests are about equally balanced. Sort of good, sort of bad, but not definitive either way. If the kids are kind of a wash on this, and I know this is a hypothetical and it's not very realistic, but if the kids' interests are kind of a wash, should then the parents' interests be controlling? How many say the parents' interests should count a little bit more if the kids, there's not a clear indication? Okay, so some people going in that direction. Now, a little other twist on this. Assume that the court prohibits mom from moving. Being a good mom, she's attached to these kids. She doesn't move. She gives up the engagement. She gives up the job, the relationships with her family, and she stays. How many of you think her relationships with the kids is going to be affected by this? Okay. How about her ability to co-parent with Dad? Okay. So pretty complicated. Sounds like we have a lot of intertwined kinds of interests here. How do we balance that? How do we juggle that? And we'll see what our panelists have to say about this. Let's talk to Dr. Ricci. Dr. Ricci, suppose that you begin working with mom, and you learn that the son not only will be slowed down scholastically if the move takes place, but he'll have to repeat a year in school. But you're working with mom. Are the son's interests paramount? I mean, the audience was pretty clear about this, that, you know, the child's interest should take over mom's, maybe. How do you deal with that kind of situation?
Well, first of all, I would start thinking outside the box, which is pretty much what I do in my practice anyway. Because when you have a child who has a diagnosed learning disability, whatever that is, because as you know, learning disabilities are very broad, and I mean that's an umbrella term for you don't know what. There is issues in terms of his social relationships, and then there's something else that's going on here. I'm very interested to find out more about mom's parenting and dad's parenting. So I wouldn't look just at mom, and I might even ask if there's some way I might even be able to interview dad or talk with dad. That's really going outside the box. But I might consider it, and I might talk to her about it. Because if we're looking at best interest, and I am not going to be making a decision or a recommendation in terms of a move. I am looking at this client and this client's child. If we're looking at this and we're thinking about the best interests of the child, if the mother is saying and we've come up with an agreement for our work together that includes more effective parenting on her part, for example. And that's one of her objectives for our work together. Then I have a clear road here to begin to examine this, quote, learning disability and her relationship with this particular child. The way you're setting up this hypothetical, I really have a lot of red and yellow flags coming up all over the place. I want to know what this relationship is, because a child with a learning disability requires the cooperation of both parents. And it also, if you're really going to be effective, you have to do a lot of investigation. You have to be right on target. You have to be on top of this situation. You can't let it get to the point where someone is going to say the child is going to be held back. Things have gone too far, and I'm interested in knowing where that parenting is, what's happened, where did the parenting break down? Perhaps it broke down somewhere as the marriage was breaking down. Father is it's kind of a mysterious figure in this hypothetical right now. So I have a lot of questions, but my first thing would be to ask to speak to the psychologist, ask to speak to the teacher. Just like you have different impressions when you're in a family, different teachers have different takes on their students. One student with a learning disability is going to do well in one grade with a certain teacher, and then maybe the teacher becomes ill and another teacher comes in. That child doesn't do as well. So you have the personalities at school to also take into account. So that would be one of the things that I would do.
Okay. David.
Yeah.
Imagine that you are representing Dad as a lawyer, okay? So get on your lawyer hat here, and we'll see if we can make you chafe a little under this role. Assume that you are representing Dad, but you learn that the 15-year-old is having unprotected sex with the 24-year-old drug-dealing boyfriend. And in hypotheticals, we can know these things. She will become pregnant if she doesn't move. Dad is adamantly opposed to this move. You represent Dad. Can you take the interests of the daughter into account? How are you going to deal with that? Do you get uncomfortable in this role?
Very. And I'm particularly uncomfortable with, worrying about the daughter here, because one of the things that I think that we lawyers are not trained to do and could benefit from more training is systems thinking. In other words, what is the impact on Dad if he wins? And the daughter doesn't move away, does get pregnant, does contract a sexually transmitted disease, marries at an inappropriately early age, given her otherwise expected trajectory in life. That may have an unwanted effect on him. Now, I mentioned earlier about how collaborative law gives us a very powerful and important tool. And that is, we can go back to the client and say, remember when we started the process, we all signed an agreement saying we were going to look at what is the best interest of the children. We're all going to be thinking about that. And that gives me an ethical and appropriate, professionally appropriate way to have that conversation with Dad and say, as we've heard from the other panelists, this is not about win-lose. There's another issue here, it seems to me, that we lawyers are not well equipped to think about by training, and that is sort of longitudinal systems thinking. The issue is not just what happens in the next 6 months or a year, but what happens in the next 5 years, 10 years, 20 years, this whole family system. I heard one mediator, who was also a lawyer, describe the process of going to law school as a process in which the left brain circles around the right brain and eats it. I think that's a very accurate description. And so for this mediator, the process of becoming a mediator is all about recovering right brain function, which is not only intuition, but it's also the kind of systems thinking, which I think we can enhance with training. And I'd say the same thing is true for collaborative law attorneys. We need to develop that ability to do longitudinal systems-based thinking and help our clients think outside the box. In other words, help them see the unforeseen consequences and the unintended consequences of what might seem to be a victory for them. Let me just throw in one other thing. I think all the mediators in the room have probably heard and perhaps used the expression that John F. Kennedy used, I think it was in his inaugural address, where he talked about the Chinese word for crisis having two components, two pictographic components, one meaning danger and the other meaning opportunity. And so in the facts that you've described, it seems to me there's clearly danger, all kinds of danger, but there's also opportunity, because a very good thinking outside the box solution here might be family therapy or a therapeutic intervention with dad and the daughter. There might be other ways in which this crisis can be turned into a wonderful opportunity for this family system. I also want to say something about, we've talked a little bit about how dad's interest or the parent's interest could be affected by the welfare of the children. But I want to flip that around a little bit, because the purpose of this plenary session is to talk about the ways in which parents' and children's interests might be in tension with each other. I think that we often don't focus on the extent to which the children's well-being is affected by the parents' well-being, the parents' ability to accomplish their goals in life. Because especially in the crisis of divorce, children begin to take on, unfortunately, sadly, this parentified sense of responsibility for their parents' welfare. And one of the benefits of psychotherapy, for children if they're at an appropriate age, is to help separate them from a feeling of responsibility for the divorce, for their parents' well-being, and so forth. So this systems thinking is incredibly complex. And I would encourage those of you who, like me, are lawyers and are not also therapists. I saw a lot of dual and triple hands go up. So that's one of our career-long projects, is learning more about this kind of thing and encouraging our clients as they move from the divorce. We see one slice of their life, but to give them the encouragement to do their own growth and development and deeper understanding of what their interests are, what the kids' interests are, and learning how to disaggregate those two and recognize that those two things might be separate.
One thing that I think judges should be mindful of and try to do is that instead of looking at it in the lens of whether it's the kids' interests or the parents' interests or the children's needs or the parents' needs, take the emphasis off of the pronoun, whether it's the parent and children, and look at the needs of each. And try to weigh and assess what the needs are, irrespective of whether they're the parents or the child's, because they are so interwoven. And David, I think you hit the nail on the head. You cannot look at children's interests without looking at parents' interests, because there is a ripple effect and they do affect one another. So you need to be really mindful of the implications of how one decision may have a number of consequences. So those needs will vary in terms of the weight ascribed to them over time, or depending upon what the particular needs may be. So you really need to have a much more nuanced look at the entire family and continue to do that over time. And I think encouraging families to come back and check in periodically is a really healthy way to do that, and it gives them that sense of ownership and accountability to their own agreements that they've made with one another.
One of the ways...
I was going to ask you a question, but go ahead.
One of the things that I've been doing in the last couple of years, and this has to do with best interests, because I have been very interested in the research and some of the thinking around the whole concept of resiliency. There are many different studies, an international project, for example. The international project out of Alabama State, one of the things that they found, that this is several years old, maybe 2002, something of this sort, because it's still ongoing, is that in the international survey of resiliency factors, that only about less than half of the parents were resilient themselves. So you have to ask the question, how can people who don't have those skills themselves, how can they pass them on to their children? I then resolved to put those two things together, which was, one, I was going to make sure that I emphasized resiliency factors, because these factors they go across all age groups, all the way from being a young child to being an old person or a dinosaur like me. 74, that's a long time ago. It crosses all age groups. So you take people who do not have a lot of resiliency skills. For example, problem solving is a resiliency skill. conflict resolution would be a resiliency skill. Being able to identify and work with and express emotions, or what would be called emotional intelligence, is a resiliency skill. But if you don't have that, and then you also go through the process of divorce, then it becomes even more frightening and even more, there's nothing scarier to a child than having parents who are confused and afraid themselves. And so it is in the best interest, I think, of the child for parents to become educated, because good parenting will not just be about communication and about structure. It'll also be about teaching skills.
So it sounds like we have some consensus here about not looking necessarily as competing interests of family members, but that it's much more complicated than that, more combinations of how to work with this as a family unit, as a system perhaps, depending on how you want to characterize it. Maybe even grandparents might get in the picture, or some extended relatives, or step-siblings, or whatever. We could make this even more complicated. How does that fit with our current role boundaries? Our role boundaries for professionals, our friend, you've talked about care not to go into therapy, not to be advising on the law, depending upon what your role is. Do those boundaries protect us from malpractice, from really making big mistakes with families? Or do they need to be more permeable? Are they constraining us and saying we could be more useful to families if we could step outside these roles, as you said, thinking outside the box, trying some different things? Do you feel that tension as you go through your daily work? Do we need more roles, fewer roles, differently defined roles? Yes?
I've had a very interesting experience, because I thought that I would talk about some of the work that I do as being along the lines of a divorce coach. And what I found out was the term coach in California, where I practice, and my professional association, which is the California Association of Marriage and Family Therapists, which is somewhat separate from the American Association, even though they're connected. They frown very heavily on calling yourself a coach. And there have been lawsuits with people who are doing coaching who are also therapists. And so after many conversations with them, because you cannot go into the therapeutic area, although I'm sure some coaches do, I finally made the decision that I would not call myself a coach, and that I would work as a psychotherapist, even though I would use the coaching tools. In the same way as I'm not calling myself a mediator, but I am using the mediation tools. And I may come up with some agreements, and I may work with attorneys, but I am not going to fall into that box of just being a mediator. And for me, this works.
One of the interesting developments in collaborative law has been the concept of team-based negotiation involving coaches. And I think for me, because I see my role, my expertise, and the data that I'm working with as limited and constrained, the best way for me to deal with those role boundaries is to work in a team. And that's why we have a financial planner. That's why we have a psychologist who work with us on these cases. One of the things that I think as mediators, one of the role boundaries and constraints that we are taught is that we are to be impartial, and we are responsible for the process. The parties are responsible for the solutions, for the answers, for the substance. And I think that as I talk to mediators around the country who have done this for many, many years, I see mediators being more willing to answer questions that we were trained to resist. What do you think is fair? What do you think is reasonable? What do you think we should do? What do other people do? What are the courts doing? That whole panoply of questions we were taught to artfully dodge because it's outside of our role. And I think that what the most experienced mediators, at least some, are becoming comfortable doing is sharing, perhaps by the kinds of questions we ask, something of our life experience, something of our professional experience, to help guide people in a direction that reflects some elements of what we hope on our best days will be wisdom. The parties are yearning for that kind of input from us, and we have to figure out how we can share what we know, what we've experienced, while at the same time honoring those ethical rules and professional boundaries that do constrain us. It's a very interesting balance.
I'm just curious, people in the audience, how many of you feel a tension between, the new family system, looking at the interests of all the people, conflicts with some of the roles that you perform as professionals? Anybody feeling that tension? Okay, quite a few folks. So something interesting to discuss as we go through the conference. You want to make one, and I have one quick last question we want to get to.
Sure, just one comment from the judge's perspective. Family courts are very different, and our rule boundaries, I think, are very different from what a civil or criminal court might be. In a traditional court process, you're used to judges sitting on a bench and calling balls and strikes. Either the evidence comes in or it doesn't. But in the family court context, judges really do need to stretch those boundaries. We can't do our jobs well unless we are able to bring in other resources into the court and to be engaged in the community to know what resources are available for the families who are coming in, whose lives we're affecting day in and day out. So it's a very different process. And as well, many of the families coming into court are not represented by counsel. They don't have the benefit of a David or an Issa to assist them with their cases. So we need to perform the role more of an inquiring magistrate, if you will, to make sure that we are eliciting the information that we need to make good decisions. Because the quality of our decisions is so impacted by the quality of the information that we're receiving. And if we're going to sit back and say, well, I'll just listen to whatever you have to say, and you don't engage actively with the families who are in court, I think you're not doing your job well. So you need to go beyond that. The National Council has been working vigorously with the American Bar Association to encourage them to change the code of conduct so that judges can have an actual affirmative obligation to be involved in their communities, to know what's going on, to make sure that you've got the resources that are needed for your families, and so that it's okay for judges to go out into the community, to lobby for these services, to speak on behalf of the families who are coming in, to participate in domestic violence coordinating councils, to participate on fatality review committees, to do the kinds of things that bring the court into the community. It's so desperately needed, and we can't just say that it's okay to sit back and just watch the world as it goes by. You really do need to have a different view of your role as a family court judge.
And just in closing, if we could hear a couple comments from each of you. We've taken a fairly straightforward kind of situation here. What if it was a high conflict case? What if there was domestic violence? Would this conversation be different? We may have to wonder about that since we're almost out of time, but if you have a comment on that, or do you have some ideas about where you think this will go in the future? Will professional roles change as we consider more broadly perhaps the needs of families? Everybody may not agree that that's the appropriate way that we should go. So
I think with domestic violence, it does change the landscape completely. You need to be very sensitive to the impacts of domestic violence on children. There is a huge amount of research, both in this country, in Canada, around the world, on the impacts of domestic violence on children, whether it's physiological impacts, psychological impacts, cognitive impacts. And what we do know, though, is that the impact of violence in the lives of children varies by age, by gender, by the extent and severity of violence, by whether they are physically impacted by it or psychologically. There is so much information out there, and it's naive to say that one child is affected just like any other child, or that even within a family, kids are impacted in the same way. So when we see domestic violence in the cases that we have, you have to put on a different process of doing what we call trauma impact decision making, to make sure that you're looking at each individual child and how that trauma has affected the child and what the best decision for that child vis-a-vis each parent will be. I know we're short on time, so I want to hear the other.
So, I don't differ with anything that you said about domestic violence. I want to focus on the other part of your question about high conflict parents. I think that one of the questions we have to look at is this an irremediably high conflict case? My colleague Richard Wallman, psychologist, shared with me and with the parties in a case a wonderful metaphor which I pass along to you in case it's a useful tool in your toolbox. He described to a high conflict couple their role, and he said, imagine yourselves as the co-pilots of an airliner. And this is before 9/11. Imagine yourselves as the co-pilots of an airliner, and the kids are the passengers. And remember how important it is to keep that cockpit door shut, and also to turn off the intercom when you're having a conversation that isn't something other than a soothing message like you're cruising at 30,000 feet, everything's fine, we're going on a plane. You know, if you have an argument, turn off the intercom. And remember that those teenage kids are going to be right up at the cockpit door with a glass because they want to listen, and they're going to try to open the door. And sometimes a metaphor can be a very powerful tool to help people reconceptualize their joint interest with each other and with the kids.
I have a metaphor I'm going to share, and it fits right into the one that you have. What David is talking about is keep the conflict away from the children. My metaphor is handle the conflict. And it's like this, and those of you who've been in workshops with me in years past may have remembered this, but it's still a good one. And I call it the leaky boat. The children are on the shore. A mile from the shore, there is a rowboat, 2 oars, 2 parents, and a leak, and a pail, can. Now, what are you going to do as parents? Are you just going to keep bailing out? Or are you going to get to working those oars? Or are you going to say, you know what, the leak is at your end of the boat? You take care of it? Because everything the children need is in that boat. And if you get caught in that strong current and you don't figure out how to get to the shore, you're going to get way over here, and your children are going to be left over here. And it is that metaphor which really, I would say, it's the type of thing that I would hold in my mind, and one of the reasons why I wanted to do work with children and why I wanted to write for children. And that is, you know, our clients, whoever they may be, they're going into unknown territory. Divorce is very scary. It's territory. It's got a new language. It's got these dangerous things happening here, there, and yon. You've got to pay a lot of money to a lot of different people, and you're feeling terrible. And the thing is that parents feeling this way, their children are also picking up on all of this, even if they have the intercom turned off. The kids are picking it up. There's one kid said, "I'm not stupid. I know what's going on. I know, and I want to know more." So that's the other metaphor, is the leaky boat.
Well, by my watch, we're out of time. I think one of the tasks of the opening session is to raise a lot of questions for people to answer in the other sessions. So I hope that we've done that. Thank you.